Bloodworth Law was established by attorney L. Reed Bloodworth as a solo firm in 2016 to provide clients with the highest level of legal representation. Reed and the Bloodworth Law Trust Litigation and Estate Litigation teams work with a client's needs in mind so that their legal rights come first. Reed is a 2022 U.S. News & World Report Best Lawyer for his work in trusts and estates litigation. Here are a few examples of the kinds of cases that come up frequently in Bloodworth Law Trust Litigation and Estate Litigation. A beneficiary is suddenly cut out of a will. Drastic changes are made to a will or a trust. Siblings, whether biological or adopted, are cut out of wills or trusts by step-parents. Reed finds that many cases involve someone who was or should have been a beneficiary for a trust, an estate, or both. But through some bad or improper act of another person, oftentimes it is a family member, they were removed from a trust or a will, and then that other person benefited from it. Whether you're a trustee trying to defend your actions or the beneficiary left out of a family trust, your dispute has to be reviewed by a skilled Florida litigator. Be prepared to act quickly to meet Florida deadlines for filing disputes after someone passes away. There are many ways a beneficiary can be cut out of a trust or an estate, and should this occur, it will very likely involve heated family disputes, sibling rivalries, and financially uncomfortable discussions between relatives. One type of trust and estate litigation case that Reed sees involves families where the children are questioning a will because a mother or a father remarries. The children are suddenly left out of the will. Maybe the mother dies first and the father gets everything. Or the mother remarries and leaves the stepfather all the money but leaves nothing to the children who had been included in the estate up until the time that the parent had remarried. This mother and father divorced and mother passes, dad remarries is a typical situation in trust litigation. Dad's estate plan had always said that his daughter would receive an inheritance. There are multiple previous inheritance and estate planning documents that state this. Later in the father's life, he's sick and has dementia, or he's got Alzheimer's and is on medication, yet he and his current wife, the stepmother to my client, the daughter, have new wills written. The father had used a certain attorney for a number of years, and then, with the new wife, he switches attorneys. Now they have what's called a sweetheart wills and trusts drafted. It's called a sweetheart will or trust because when a first spouse dies, all assets remain in the same irrevocable trust, but for the surviving spouse's lifetime. This means that a surviving spouse can have complete control of a Florida trust. In this case, the father's estate planning, as seen by a simple mind, would read it and say, okay, this is going to give a sort of life and estate to my wife, and my daughter is going to inherit things. However, there was a provision in the trust that gave the wife the authority to basically take it all by pulling it out of the trust. This is where trust and estate litigation cases often begin, with new spouses, divorces, or marriages. He, the father, passes away. Immediately upon his passing, the wife takes everything out of his trust and puts it into hers. Therefore, the daughter literally gets nothing. Reed filed a complaint for undue influence, lack of mental capacity, and forced interference with a testamentary expectancy on behalf of the daughter who was previously included as a beneficiary. It's settled at mediation, but Reed went through it and got testimony from financial planners, from prior attorneys, from the current attorney, and was able to get testimony. There were files and documents that showed basically if you drew an overview of the estate plan, it basically had an arrow that always went to the daughter. Reed was able to show that it was the father's intent that the daughter would always receive an inheritance from his estate. There was also medical testimony that, yes, he suffered from dementia and things of that nature. So it was a pretty contentious litigation, but it finally went to mediation, and they settled and paid the value of the estate, which was close to 7 figures. Reed built a legal team with attorneys committed to working in the client's best interests. And before accepting any case, the Bloodworth Law litigation teams consider what a client wants to ensure legal options and representation are right for the client. Bloodworth Law's attorneys can meet with you in a convenient downtown Orlando, Florida office location with plenty of free parking, one in downtown Orlando, the other in downtown Winter Haven. Talk to Reed about how Bloodworth Law can help you, your family, or your business.